Hi, folks. Welcome to Wills and Trust, the three big mistakes to avoid. My name is attorney Christopher Barber, Chris, with the Barber Law Firm here in Houston, Texas. I'm licensed all over Texas and I look for reasons to travel through it. So let me know if you need me to come out to the hill country. Anyway, to get started, did you know that according to the ARP, the average estate loses 5 to 7% of its value going through probate? Not to mention potential years of struggle through the court process and maybe even problems with your family. I'm hoping this webinar to show you how you can avoid that. Anyway, oh wait, sorry guys, they're gonna tell me these things. They're gonna tell me what my tie is. Is that better? Pull me out here. Anyway, okay, with that in mind, let's switch over to the slides and we can get started. Okay, let's do this little bookkeeping. And there we go. What up? I don't need this up on the side either, do I? No. There we go. Anyway, now I can hopefully just talk and not be so distracted by me seeing my own picture on the screen. So during this webinar, I promise to try to teach you these different things. How to make sure 100% of your assets go to the people you love, how to avoid Texas probate, the difference between a will and a living trust, why putting assets in your children's name may be a mistake, how to safeguard an inheritance from divorce, lawsuits, creditors, irresponsible spending, and even more, how to provide for beneficiaries who receive government benefits and protect them. Important stuff, huh? So, what is Texas probate? Why do you want to avoid it? Things you need to avoid and how to plan for success. Because remember, failing to plan is a plan to fail. Plus, if you stay until the end, we have a giveaway. So stay tuned. Hopefully, it'll provide even more insight. So about me, I'm Christopher J. Barber, Chris. I've been licensed as a Texas attorney since the 1990s. This is the focus my law practice has always been in. I also have a law enforcement background. So if you're in the Houston area, say hi to me if you're in Bel Air. I work with them sometimes still as well. Being a cop is extraordinarily rewarding. My office is located over here by Rice University, and feel free to stop by and say hi. Also, if you have any questions, please fill them out in the box below. And if I don't get to them, I'll get an email and I'm happy to respond to them after the webinar is complete. So, probate, why do you want to avoid it? Well, probate's not evil, but guys, it's absolutely unnecessary. And in my opinion, why would you ever want to go under the magnifying glass of the government when you can do things to take care of this without any government involvement at all? That's my preference. Again, it's not evil, but it is unnecessary. So let's first talk about the Jackson family. I'm going to use names that are not the originals, obvious reasons, but I am going to try to make it as real as possible because everything I'm talking to you about here has happened in my practice in one way or another. And that's an issue because I'm just one lawyer and look at all the stuff that's happened. So when I met Lisa Jackson, when she first called my office, her husband Thomas had recently died without a plan for any of his assets. They had about $450,000 in assets, including the family house and rental property. Lisa also found out that Thomas had an account with about $12,000 in cash. Not huge money, but not chump change either. Because Thomas didn't even have as much as a will, I had to tell Lisa that assets would have to go through the probate. It's interesting, a lot of people think if you have a will, it avoids probate. Nope, where there's a will, there's a probate. And even more so, if there is no will, there's absolutely probate. Probate basically means to prove, and it's basically there to prove the will you have is valid, or if there is no will, to prove who your family is, because the courts don't know who your family is. Now, in Texas, there are two types of probate. Independent administration for those who have a properly drawn will. This process is generally quicker and cheaper and relatively straightforward. It may be why you hear Texas has streamlined probate. Well, it's still court, but compared to places like California or Massachusetts, it's very streamlined. But in this situation with Lisa, they would have to go through what they call independent administration. This includes additional processes, including an heirship determination. For dependent administration, Lisa would need to pay her own attorney to prove that she had the rights to the assets. Because again, the judge doesn't know who Lisa is. You know who she is. Lisa knows she's the wife. The court has no idea. And here's what's interesting. Not only do you have to pay your attorney, the court has to appoint another attorney and you pay for it. This is called an ad litem. As for the process, first I had to file and then wait until the court appointed the ad litem. That took a couple of weeks. And then the ad litem had to get on the case and do their part of it. Regrettably, an ad litem may not have as much motive because their fees can be fixed sometimes to get things done. So this cause even further delay. Overall, it costs Jackson family about $7,000 to get this probated. Now, in a huge estate, that may not matter. But if you're a more modest estate, $7K can be a big cut out of it. All the studies show that probate fees are much more substantial and have a bigger impact on smaller estates. And whether you believe it or not, you do have an estate. So this is just what happened because Tom passed. Lisa also has to consider, because there's been no planning and she continues no planning, her family, her kids are going to have to go through a similar situation when she passes. This could all been avoided by having a proper plan in place. So when don't you want to come and be in my office? So like many attorneys that focus on estate planning, there are two ways I can help people. One is in my capacity that I explained in the previous story. However, I'm not a litigator. I don't want to find another attorney and a family member or many family members trying to get through the probate process. That can be a real pain. A lot of attorneys make a lot of money that way. But the reason I put this presentation together is because I don't want that to happen to your family. The other way I can help is by helping them plan ahead. When somebody plans ahead, there are much easier options to go through, which we'll get to later in the presentation. But first, let's start with a situation that we're trying to avoid. Texas probate. The process of dividing somebody's assets up after they end up passing away is known as probate. As I said earlier, probate basically means to prove. Prove a will or prove who your family is, and then prove all the details that need to be addressed when somebody passes away. There are different rules for probate in different states, but we're obviously focusing here in Texas. So what you have to realize is that laws in place are meant to be fair. As you can imagine, there is sometimes a lot at stake financially, and people sometimes try to sneak things in to get more fair, to be more fair. Don't you like that? With other people's share of an estate. We're talking about made up documents, forcing people to sign things under threat, and all kinds of stuff you'd never dream of. Yes, folks, we're talking shenanigans. When there's money involved, people may do bad things. And when they say it's not the money, guys, it's the money. Or it could be emotional. When little Johnny was told at 12 that he would get grandpa's shotgun, he wanted grandpa's shotgun. Unfortunately, he told it to Timmy as well. What happened to both of them? In their mind, at that second, that gun became theirs. Now they want it. You can't split the shotgun very easily. So in order to avoid this, you either need to provide very specific instructions to the state on how you want your stuff to be handled, or go through the process for the government to handle it for you. The state does have a plan for you. It's through a big, thick red book right now called the Estates Code. Be aware, it used to be called the Probate Code, but it's called the Estates Code now. And that's what we have to deal with. Those are the laws put in place for people that do nothing. It's also the laws on how to get through it without having the state directly involved, because this is all very established stuff. Regardless of your wishes, if you don't have a plan or have a plan that doesn't hold up in court, you're going to go to the default situation, which is to split things evenly. That means your bank accounts, your home, and anything else you have. The estate is going to appoint things called the executor, who will be chosen by the court if you don't appoint one. And actually, it's called an administrator if there's no will, or in a will, it's called the executor. That is just another word for manager. Somebody has to be in charge of this or nothing gets done. And that's what we have to have happening. And according to the costs, according to the probate code, we don't have an actual set fee. We have established, you can negotiate with your attorney what pricing is. There are things out there that are pretty set because we do things because we know how to do it. I personally try to stay with fixed fees because I don't want to surprise you. I don't want you to be, oh my God, I got to call that dang attorney. He's going to cost me $200 just to call him. I try to avoid that. I put my cell number right on my business card for you to call me when you need to, because I don't want you to be afraid to call. I've only had that turn bad on me once, and I'm kidding about that. They called me about 8 o'clock on a Sunday night to let me know their dad had passed. Okay, that's why the number's on there. But the estate is going to have to go through the executor, and we have to follow through with that. Also, if you want to have a shock, go look up the statutory fees in the state of California. They start at 4% on the first $100,000. Wow, that's $4,000 just in attorney's fees. And by the way, the executor, the manager, gets paid about the same. Out of a $100,000 estate, that's $8,000, give or take. That doesn't include the court costs or the newspaper publications. We just need to be aware of this because the state does have a plan for you. And according to the probate code, like I said, is not set. You set it up with your attorney. But some attorneys will charge by the hour, especially the big firms, because they know and understand hourly billing. So if they're charging you $500, $600 an hour, that can get going and get costly very quickly. So we got to be aware of that. Also, their timelines. The estate's code establishes certain parameters in which you have to have things done. If you have a will, did you know you must have it probated within 4 years of the person passing? Wow, if you don't, it's going to go into the much more difficult dependent administration. Also, you have to make newspaper notices, you have to notify beneficiaries, all this stuff through the courts that takes time and money. And that's what we try to avoid. We try to minimize that. Also, COVID, it's affected us all and it's slowed down the courts. Now, it has brought the technology to the force where a lot of these things are doing Zoom hearings. I've given these seminars in the past live. It's seminars I present around the city, actually around the state. But now with COVID, I'm doing an online seminar, webinar, workshop, however you want to label it. Hopefully it provides some useful information. But COVID has made things more difficult and more time. The courts are backed up. They're not doing things live. Some of them are starting to do it. I've had to drive out to LaGrange for a live hearing, had to drive to Galveston. It's what I do. I've also done some in my office that was very streamlined. You can come by here and do it with me if that's what happens. Now, as I said earlier, there's independent and dependent administration. This is an extreme wrinkle to Texas. That's why administration of estate is I can't even talk. With documents like a will set up property, you have an independent administration. It has to be noted in the original will or more work has to be done. It's your decision. You're making it. You got to do it yourself. It is one of the problems with homemade wills or even LegalZoom. They will often promote the fact that their wills are valid in all 50 states. That may be true, but please realize valid is not the same thing as efficient. And what we're trying to do is be efficient. And going into a dependent administration with the extremely higher fees and times involved usually doesn't make a lot of sense. There's also the big issue, as I mentioned, what is the main reason for probate? Pay your creditors. Just because you pass away doesn't mean that Visa doesn't get paid. And by the way, did you know that if nobody else brings your will or your estate to the probate courts and the money's just sitting in there, your creditors can sue in the probate court to be your manager? Visa is going to be the manager to make sure they get paid. They have every right to do that. Kind of probably better for you to plan away from that. Also, wills are public record. Now, before you pass, you keep it whatever you want. But once somebody passes on, the will has to be filed with the probate court, the county clerk in the probate court, and it's made public record. I've literally taken an Uber downtown to file the original will. By the time I got back to my office, it was already posted online for the world to see. In the old days, that was the legend was that's how aluminum siding salespeople got their leads. They looked to see who just passed. Look, Mabel just is going to get a lot of money from her husband's probate. Let's go sell her aluminum siding. Okay, may not be the way you want to get solicited for whatever it is. But anyway, that's what you need to do. You need to start the probate process for your creditors to get paid. However, you don't have any privacy in it. And just one more thing to be aware of. Also, guys, how well do you really know your siblings? The last and most important drawback in going through probate is the toll it may take on your family. Have you ever heard a joke about families that don't speak to each other for weeks after just a heated game of Monopoly? Well, dial that in about 11 times because probate is doing that in real life with real money and real houses. All the events that I've mentioned in this section are stressful in and of themselves, not to mention the fact that people have to grieve. Wow, you have to grieve and take care of all this. Jeez. You may think you know your siblings or your kids, but can you tell with certainty there is no way to know, there is no way to predict how they will act when money is on the table? Probate proceedings can change lives, and it's rarely for the better if things get ugly. When you don't have a plan for how you want your wishes to be carried out, your family will be in a contest of a will contest. Please be aware, will contests are litigation. Litigation can be ugly and litigation can be expensive. So that is why I'm trying to bring you ways to avoid that. So where are we? The biggest mistakes. Ugh. Look at that. Boom. So sounds like probate may not be the right way to go. But unfortunately, getting a plan in place isn't as easy as signing a piece of paper. It really isn't. You really got to know what's going on. Let me tell you another story, a few ways I see this going wrong. The Davis family. See, it says it right on the screen. Mary and Greg Davis were a married couple, and they both had wills they'd done years before. Greg passed away unexpectedly from a heart attack. While Mary was mourning the passing of her husband, she got more bad news. Her husband had left behind a brokerage account with about $600,000 in it. Real money, guys. In Texas, this is a community property state, so Mary thought she had the rights to it. The problem is the brokerage account would not release the money until Mary got letters from the court because the accounts were only in Greg's name. These are called letters colloquially. They're letters of testamentary if there's a will, and letters of administration if there is no will. They are a court order saying that Mary had the right to deal with her husband's stuff. Yes, she technically had a right to it because she was married and it was set up while they were married. But if the mortgage company is saying no because they want a CYA, which I hear has a meaning other than call your attorney, she still had to go get this court order saying they must deal with her. She could have sued them to make them go by the law, but that would have cost money and again been litigation that's much uglier than it should have needed to be. Eventually, she realized if something wasn't done, that she wouldn't get the money and that she couldn't handle it on her own. So she came to me for help. We did wait the statutory periods, but even with that, we couldn't get a court hearing. And this is me expediting everything as much as I could. And I remember it was down in Galveston County. It took us 6 weeks before we get an actual hearing. In the meantime, she couldn't do anything about the stocks that were losing money. We had to wait for the letters of testamentary to be issued. And guess what, guys? In that 6 to 7 weeks, coming to me getting things filed, she lost $160,000. Oh my God, that could have been completely avoided. Now, after all this was done, she did see the advantage of planning, and we did set her and her family up a trust. And hopefully it will be easier for her kids because she doesn't have to deal with the court and that delay. Yeah, Chris, I know all that. I can do this myself. Or I have an attorney who just got out of school. He'll do it for me just for a couple $100. Or worse, go to a trust mill attorney or a trust mill, and somebody who's not an attorney says, oh, you don't have to pay those dang attorneys, are too expensive. And then they set up a trust for you, or even some other kind of planning, and they may charge double what I would charge you. And they're not an attorney. Technically, that's improper. That's illegal. But hey, guys, trust me, I'm not an attorney, but I'm going to set you up. Be careful about that. Just please be careful. I mean, wills and trusts are really powerful tools when used properly. But as you can see from the story, the devil is in the details. Can anyone who passed the bar legally provide you with a will or a trust? Yep, they can. But as you can tell from the story, 99% correct will or trust is worse than no trust at all. I call this type of situation the yeah, I can do that attorney. And these are often personal injury attorneys, divorce attorneys, or whatever. They can do it, but should they? I am not the attorney to come to if you're getting a divorce. I'm not the attorney to come to if you get into a crash up on 610 or an I-35 in Austin or I-40 in Amarillo. I am the guy to come to if you need to get your estate plan set up in hopefully a very efficient and streamlined manner. Any minor mistake can lock you and get you stuck into the probate process. It's not what we want. It just doesn't make that much sense. Well, there are DIY solutions. We've all seen LegalZoom. We've all seen fill in this blank wills. Guys, those things are going to make some attorney somewhere way more money. I have literally seen wills come to my office that say, I leave all my assets to, and there's a blank line. What do you do with that? Not to mention somebody just filled in their name. Now, courts don't like those. Also, they are, again, maybe legally sufficient to be valid. But again, valid does not mean efficient. And what it really does, which is chilling, it gives people a false sense of security. Also, oftentimes those homemade wills don't have witnesses, or they don't have witnesses set out properly. When we have a witness to make sure there are no shenanigans, that grandma or mom or sister Susie is actually competent and knows what she's doing at that moment, we also need to know that it's sworn, there's a sworn oath accompanying the average will that is a substitute for live testimony. Because when this probate when this will, goes through probate, there has to be testimony that everything was done properly. Well, those witnesses may not be around in 40 years. So what do we do? Well, if we do things right, we have documentation that shows the witnesses were valid and competent and in Texas over the age of 14 as a substitute for testimony. But guess what? This already means you're in court. You're having to provide testimony to the judge. That's more costly and takes more time. So we want to try to minimize that. Now, I've been talking about the alternative. There's wills and there's trusts. We'll get to the details of that in a moment. But what would you say the biggest problem with having a trust? It's not funding it properly. The way it avoids probate is for people. The trust is not a people, okay? But we put ownership indirectly or into the trust, where the only people that can do anything with the trust are the trustees. Where I said earlier, the executor is a manager. The administrator is the manager for the estate. The trustee is the manager for a trust. And when you set up a trust, you're the manager. You're the one that makes decisions for it. And by the trust owning your assets, when you pass on or become incapacitated, the trust continues. Probate's for people, the trust is for your assets. So when you pass on, nothing changes in the trust. It's already valid. All that changes is who the new manager is. And guess what? You've laid that out in the trust beforehand. So with spouses, okay, guys, sorry about this, but we always kill the husband first. The husband passes without anything going on, no probate, no courts, no nothing. The wife remains the trustee. Where she was co-trustee when the husband was alive, she's now the sole trustee. and she manages things just as before. And when something happens to the wife, automatically, without any court intervention, the new trustee that you've appointed, your oldest child, your brother, your favorite attorney, me here in Houston, steps into your shoes automatically and takes over managing the trust. And they're legally bound due to their fiduciary duty to honor the terms of the trust, which you've already established. So you got to keep but to make this happen, you have to fund the trust. That means you put your house, your bank accounts, your brokerage accounts under the umbrella that is the trust. You don't put your IRAs in it because of some tax purposes, but you would make the trust your contingent beneficiary under the IRA. It's often a good idea to make your life insurance beneficiaries the trust. Thus, the money pours into the trust, and then the trust manages it as you want to have happen. Now, the big problem with that and not funding it is not keeping the plan current. So when you buy a new house or you buy some land, when you buy it, you put it in the name of the trust. Just directly, you have the title company say to the Smith Family Trust. Pretty straightforward. And by the way, remember, I'm still there to answer questions. Have them call me if they need an issue taken care of. Again, that's part of the umbrella pricing I have. I want you to be able to call me and not be afraid of that. But there's people out there that want to try to be cute and clever, and they may do something you know about called joint accounts, joint tenancy. They go, well, I'll just put my name's already on the account with my mom, so I can write checks for her. That's so good, and it's clever. Well, you got to be careful. Two things happen when you put your name on an account with somebody else. The first one you don't think about, by putting your name on the account, you just legally made a gift. Whoa, I don't want a gift to be made. I'm going to give it back to my mom. You just made two gifts. Oops. Now that can be taxed. It may depend under these circumstances. It may or may not. You're allowed to give up to $15,000 a year to as many people as you want, but you should file a gift tax return if you do that. But you want to do that 2 times because you just didn't know, but that's nothing compared to the next one. When you put your name on an account jointly with somebody else, they become the owner, and they can literally take all the money out and fly to Vegas and spend it on a wild weekend. Okay, you know your kids wouldn't do that to you. But here's what's more pressing. It's their money legally as much as yours. It's joint for both of you. If your child gets sued, they can take your money because it's their money too. And remember, divorces are lawsuits, and they're going to go after the easiest money they can get in a lawsuit. Cash is the easiest thing to get usually. So that means your savings account that you own jointly with your child could be subject to your child's lawsuit. Now, there's also things called courtesy accounts. Talk to your bank about it, where your child or whoever is just a signer but has no ownership. Make sure you know the difference because it can make a big difference. So you need to plan when you can. I know it rhymes, isn't that cute? But like I said at the beginning, failing to plan is a plan to fail. And we really, really don't want to do that. Excuse me. So here's the anti-story. And the last story that I have for this section isn't actually a story at all. It's a story of clients of mine that have happened to pass away or become incapacitated, that had documents prepared for them, but it is also the story of those who have had it done by other attorneys who focus on trusts and estate. The story goes, they ended up reaching the end of the road and their home, money, and other assets were distributed according to their wishes. Happy ending. Now I have to apologize because that doesn't make for a super exciting listening. They refer to plays as dramas for a reason, but I like to imagine most people don't want to have the story they tell end up making bad guys and heroes out of their loved ones, because at a time like this, they should be focusing on mourning, excuse me, and moving on. I really can't tell you how reassuring it is when I get calls from people that I did plans for in the 90s that said, Chris, thanks. What you said happened. Now, regrettably, a lot of time that's after they just lost their spouse. Yes, usually the husband. But when I can give some peace of mind, when I can help someone sleep well at night, SWAN, swan, that gives me joy. It's a simple pleasure. It gives me joy. It's helpful. My philosophy on estate planning is that I want everyone that walks into my office to leave with peace of mind. I'm providing you sleep insurance. When you put together an estate plan, it's like preparing yourself with a parachute. You may only need it once, but it better work. Even though it's only that one time, it's absolutely essential that you have it. We've gone over a lot of ways this kind of thing go wrong, but with the right plan in place, you'll be able to go through your life knowing that your wishes will be carried out no matter what happens. Another thing I firmly believe is that peace of mind comes from the right plan for you. There's no ultimate estate plan that is there for everybody. It's about what's right for you. Some people need Fort Knox. Some people just need a picket fence. So let's go into the major ways you can handle your estate. There's the anti-story. Plan is like a parachute. Now, what is a will? As I said earlier, it's basically directions to the probate judge. The first big document that you will have will be a will. And almost every estate plan uses a will in the planning phase, even though it may not ever have to be used down the road. I'd much rather have it and need it than need it and not have it. When done properly, with the appropriate witnesses, all the stuff we've gone over, a will is instructions to the court on how to divide your assets. Every advanced estate plan will include a will as well. One of the things to keep in mind, though, is that a will still requires your heirs to open a probate and it be public record in a public court with all the costs and expenses associated with that. The big houses you have are able to, you can avoid, and is how your assets will be divided. So assuming everything is done properly and is up to date, you can save your family. Yes, I'm reading this part here. The conflict of deciding who gets what's a longer timeline associated with hearings, in most cases, avoiding litigation between family members down the line. Okay, so that's a will is basically instructions to the court. What is a trust? A trust is a much more sophisticated document that gives you flexibility to divide your estate without going through probate. You can put your house, bank accounts, and anything else into the trust, and by passing the trust itself through a will, you're able to avoid probate entirely. Pretty cool. Trust also allows you to choose how and when people receive their assets, which can be a very important thing in some situations. Now, you can set up a trust in a will, but then you have to go through probate to get the trust to be activated. Thus, you are having both the cost of what it is to set up the trust and then actually having to pay for the probate process too, and the delays associated with probate. I don't know if that makes sense. I've never done a trust inside a will. It's never made sense for me. So do I need a will or a trust? I'll give you a classic lawyer answer. It depends. Awesome, huh? Here's a major reason I would recommend a trust over will if someone walked to my office. In Texas, there is something called a small estate affidavit. If you are worth under $75,000, excluding non-home state real property, your home, you can do something called the small estate affidavit. You set it up, file it with the clerk, the judge hopefully signs it, and it is proof that you are that you're the proper parties to transfer assets. But if you have a homestead that is not owned by your spouse, or you're over $75,000, you can't use the small estate affidavit. It'll have to go through a regular probate. For most instances, this is way above the cost of what you get if you just put in a plan in place. How about if you own a home and other real estate? You own a home, I always recommend a trust. It just makes sense to me because a home is a big asset and oftentimes tied to a lot of memories. It's one of the things we'll see fought over the most. It's a family home. It's been in the family for years. People get emotional to it. As we've gone over before, you may think you know your family. but it's very easy to get heated and fight over who gets what. If your heirs get along perfectly, you now have a situation where they are joint landlords. They all own it equally. With the equal split that is a default in state law, everyone will have a portion of the home. They decide to sell it, it's inevitable that one person will end up doing most of the work, which leads to further conflict down the road. And by the way, in an estate or a trust, you often pay your manager because it's hard. It's a pain. It's a lot of work because they don't even know what to do to ask you. You're not here with us anymore, so they can't ask what your feelings are. That's why you got to write it down. If you don't write it down, it never happened. By using a trust, you can set out specific rules for how you want your home to be handled, who's to have it to go to, how you want it sold, and who the proceeds go to. And this list goes on. It's much more flexible way to set up the rules for your specific terms. Again, the state has a plan for you, or you can write your own laws for your own estate. Now, how about people with minor children? Worst case scenario, guys, but you got to think about it. You have minor children, mom and dad are out for dinner. They leave the children with the babysitter. Y'all get into a horrible crash. Y'all both die. What happens to your kids? Oh my God, what happens to your kids? Oh, well, my mom will take care of them. Not at first. The babysitter's there all by herself. No one's coming home. Who does she call? Maybe the police. I show up as an officer. Oh, we got to take them to CPS, Child Protective Services here in Houston. It's called the Chimney Rock Center because nobody has legal authority to take your kids. You didn't leave anything in writing. Then you have to go through a guardianship. The judge has no idea who you want to be in charge of your children. You didn't leave anything for him to look at or her to look at. Wow. So you may want to leave something in writing. Oh, here's something else that's important on things when you're dealing with guardianships. You can write who you want to be in charge. You can also write who you would never want to be in charge. It's funny how I see people get a glint in their eye when I tell them that. Oh, I never want cousin Susie to be in charge of my kids or me. Terrible stuff. You got to be mindful of this. How about if you have kids or people in your family that have special needs? Well, if you just give them a large inheritance, they may be disqualified for their government benefits, which over the long run may add up to way more than any inheritance they may get. But if they just get a cash outlay, they will be kicked off most government benefits. That's terrible. But by setting up a special type of trust called a special needs trust, you can supplement without supplanting their government benefits and can significantly improve the quality of that person's life. You sure wouldn't want to unintentionally disinherit them because they really may want to be having the government benefits for their entire life. It really makes the issue important. How about this? I hope it's not for you, but what if you have a child who has a problem with drugs or alcohol or just spending money in general? Through a trust, you can very specifically restrict access. It's also called a spendthrift provision, where if they're in major debt, your trustee, your manager can say, I'm not giving them any money because it'd go right to Visa. May give your kid a chance to negotiate a better price with Visa. So if you give them 100,000, it doesn't go to Visa. Visa agrees to take 10,000 instead because they'll get it because they'll never get the 100,000. Kid pays them 10 grand. Once that's all done and settled, then your kid gets to 90. Or how about if you have a child who is addicted to drugs? Anyone who has had this problem, often any money a kid gets or a person gets that has a drug problem is going to go right up their nose or shot into their arm or just wasted. You don't want that to happen. Also, give it to somebody who just turns 18. Boy, I hope most people were more mature than I was in 18 because it could have turned into a Ferrari and that wouldn't have done much good for my college. If you do no planning, your children will get whatever you have as soon as they turn 18. By having a trust, you can delay that to whatever age you feel is necessary. Heck, I have 80-year-old parents who don't think their 60-year-old children are responsible enough to deal with money yet. Okay, here's another thing we need to be aware of. Back when I was a kid, one of my favorite shows was the Brady Bunch. Back in 1969, it was cutting edge because it dealt with a blended family. Oh my gosh, not that. Heavens forbid, clutch my pearls. Anyway, in today's world, this is pretty common. So when something happens to you, do you want to ensure that your kids get your share or what you got for them through your life? You do nothing. Your spouse and your kids may get everything, and that may be right. Or your spouse gets everything, and the kids may be disinherited. Oh my, well, that's not what I meant to do. By not planning this properly, the unintended consequences can be absolutely devastating. Also, when you're planning your estate, you need to talk about incapacity. In today's world, we're living longer, folks. However, we're not always living with our full capabilities mentally. What happens when you can't make decisions for yourself? Well, without any other planning, again, the state has a plan for you. It's called a guardianship. Guys, guardianship's a big deal. You are taking away someone's legal rights to act for themselves. That should be a big deal. So you have to get doctors involved, lawyers involved. That second lawyer that the court appoints, it's called an ad litem, to make sure that your needs are taken care of against whoever may be trying to get the guardianship. And that guardianship person is probably not evil, but they are having an interest that is against your interest. Probably in the big picture, are better for you down the road because you've lost your capacity. That is scary as heck. But by putting certain things in place, we can avoid a guardianship. You don't want to deal with a guardianship. There's annual reports. It's basically having a probate every year. You have to answer to the court's investigators or the people the guardian does. You're the ward. You can't make decisions anymore. And most of the times it's your spouse, but it may be your brother, your sister, or whoever. There's even independent guardianships. And if nobody's there to do it, the state will take it over. Not something I personally want. So guardianship is something to try to avoid. Thus, see the asterisk, these are things I really want to make you note. There are other essential estate planning documents. Some of these help you avoid guardianship. Powers of attorney, you've probably heard of these. So there's a power of attorney, a living will, and the pourable wills. There are two types of powers of attorney in Texas. A power of attorney for assets would take care of all your stuff. And this is useful if you forget to put something in the trust. The whole idea is we fund this trust properly. I will hold your hand as much as you want me to, or let you go at your own as much as you want. But if we forget to put something in the trust, or you maybe inherit something before you have a chance to put it into the trust, something happens, powers of attorney can give your agent, another word for manager, into the trust, and then your trust handles it without probate. But you have to do it before you pass, because all powers of attorney become ineffective in Texas once somebody dies. The other type of power of attorney is for your medical care. Now, if you're in the hospital, and you probably fill these out every time you go to the doctor, or every time you go get a procedure done, a power of attorney for your medical care. They're going to save your life. But after that, the hospital doesn't know who is supposed to make decisions for you. Again, they don't know who your family is. They will likely listen to your family, but they really want something in writing to let them know you're the proper person to make decisions. You can also restrict things that'll be done in a power of attorney for medical care. Doctors and nurses do this sometimes because they know there's certain procedures, no matter what is going on, they don't want done. There's also a document called, you may know it as a living will. In Texas, it's known as a directives to physician, family, and surrogates. To put it very bluntly, it's a document that says, pull the plug or don't pull the plug. And it's really important because you need to know this. In Texas, it's not like there's a legal mandate that says it has to be honored. What it is instructions, a directive to your family that you want the plug pulled or not pulled. So that way, little Johnny isn't saying, oh my God, I killed mom. No, you didn't kill mom. You honored mom's wishes. Mom did not want to be living as a vegetable for the next 30 years. That is some peace of mind, folks. The last thing is we also have a pourable will. I said earlier, a power of attorney becomes ineffective at death. Well, if you didn't get the trust funded properly and there's that new property that came in unexpectedly and you passed away, the pour over will is used only for the assets, not the trust. That means all the stuff in the trust is already being managed. So brokerage accounts can be changed around, things can be sold and bought as ever is in the best interest of the trust and the beneficiaries. Well, the pour over will is there as a belt and suspenders measure to pour in, like a pitcher of tea pours from the probate estate into the trust, and everything can be managed as we hoped for in the beginning. So it's important to know about those things. Now, there's fun stuff, more advanced planning. If you have a more advanced estate and you may be a target for lawsuits, you can set things up like LLCs, business entities that can give you some protection and some great management tools. Heck, there's one thing you can do where you set up an entity, you get sued, you lose. You don't pay the money you lost to your creditor, but they have to pay taxes on the money they never got. Whoa, that's a pretty good incentive not to sue you in the first place, isn't it? Now, it's not perfect, but boy, it's better than nothing. Like I said earlier, some people need Fort Knox. We try to help you build your financial fortress. Some people need a picket fence. You know your situation better, but if you don't know, ask. That's why I'm here. So be aware, hometown attorneys, people that are here to help you. Moving on to special modes. This is what you do and what you won't get from other firms. Me, I'm here to help you. I'm not a 57th floor brass and glass attorney. I have an office out by Rice University and a converted home from the 1930s. It's much more comfortable and much more suits my style and most of my clients' mood. When my clients work with me, they're not working a big firm who doesn't know who you are. You're working with me. You're buying my services and quite honestly, me caring about what's going on because you're definitely not just a number and you don't get thrown into a pool of associate attorneys or paralegals. I care about getting to know you. I swear I care about getting to know you. I want to know what's going on, what your situations are, what your desires and goals are. My office is in the neighborhood, but I'll come see you. I've driven to Fredericksburg. I've driven to Beaumont. I've driven to Dallas. I also have an airplane I built. That's my big hobby. And when it's flying again, putting in a new engine, I'd like to fly to you. Love that idea. Just fun. If you don't know, I mentioned earlier, I have a police background, something I enjoy doing, very rewarding out in Bel Air, if you know the area. Stop by, ask about me. Not like I won't tell people I'm an attorney. So follow up. As you've seen from some of these stories, situations can often change. We have situations with family and how your life is set up, the assets you have and are building, and even the law itself. A trust needs to be a living document. Guys, it's like the Constitution. It's a living document. It can be amended. So be aware, in a nutshell, a trust has three parties to start. The trustors who create it, the trustees who manage it, and the beneficiaries who get the benefit of it. When you set this up, you're all three. But as things develop through your life, they can change. The beneficiaries would change to your heirs when you pass on. The trustees may change because you pass and your spouse takes over exclusively, or your oldest child takes over. It's a living document. It can be modified as your circumstances change, but you've got to set it up beforehand. You've got to plan ahead. And I try to follow up with you as well. Every couple of years, I'll reach out and I will see if things have changed. And then you can come in and talk to me about what's going on. And when you set this up, because something set up right now is better than something you hope to set up in the future. If you're not sure if you know every specific situation, let's get something established. In the first 3 months, if you have any modifications you want to make, I give them with no charge. So you come in and tell me. Down the road, a couple of years, if you need to change, it'll be whatever I'm charging at the time, but we'll work at it. I'm not here to bilk you out of your money. I'm here to try to provide a service. Now, I do charge my services because if I don't get paid today, I'm not here to help you next month. So that's important. I'm not going to be here to nickel and dime you. That's why I won't charge you for a quick phone call. I want you to know what's involved up front. So what's your story going to be? Right there. That's a great it's a great segue into what I want to leave you with. We've talked about legal documents through this presentation. I've also told you some stories. I want you to think about what the story is going to be for you, what you set up with your plan or lack of a plan. This is the epilogue of your life story. We've gone over stories that end with families being torn apart. And if I can have one person at this presentation stop from that being their story, their legacy, I can consider this a success. So here we are. If there's questions and answers I haven't gone over, if I've gone something over too quickly, or I skipped over it because I've been doing it so long and so often, please reach out and ask. I know we need like that algebra teacher back in high school where he puts it on the board, and because he knows it, he expects you to know it. Well, I hope I don't do that. Call me. I talk a lot. You get bang for the buck and a quick phone call. Or when I'm offering right now, normally my hourly fee is $500 at the few exceptions that I may actually do hourly billing. It's $500 an hour. But if you follow through this presentation, because you've already come to me, you've already gotten a good background, I can give you a 1-hour consultation with no charge. So I hope that is something you want to follow through with. If this sounds complicated, come to me. I'll help try to demystify it for you. How long does it take? Usually a few weeks, but it's got to get started by you pulling the trigger. You miss 100% of the shots you don't take. Yes, I stole that from Wayne Gretzky. So there are things you can do. You can come to me. I can come to you. We can also do Zoom hearings. Here are some of the questions I've had in the past. I have a will from 11 years ago. Will you take a look at it? I can do that. It may be valid. Or you may have done it 40 years ago, put it in a drawer and forgot about what it said. I have a client who did that. His kids grew up. Unfortunately, one went to prison. Things changed. He didn't change his will. So that child in prison still got benefits that he may not have wanted him to have. Who should get copies of my estate plan? Well, under a trust, nobody needs copies of it but you. It stays private. But you may want to share it with the important people in your life. If we plan on having more children, should we do something now or wait? Do something now. 100% of something is better than, 50% of something is better than 100% of nothing. The trusts that we do are geared for change. Not only change in your family situation, but change in tax law, change in laws. Right now, we're under President Biden. He has said he wants to do some major changes in the way estates are taxed. It may affect you. It may not. Come in and find out. Okay, one of my parents went into a nursing home. Is it too late to protect their assets? Probably not. I do Medicaid planning too. Now, my Medicaid planning is limited to qualifying for full-time nursing home payment through Medicaid. But if I can save your family tens of thousands or hundreds of thousands of dollars, that's a good thing. We work all our lives so we have the money not to be a burden in our old age. And then we get to be our old age and we're going to be a burden because we haven't done the proper plan. Or this one, I get this a lot. I don't really have a large estate. Guys, as I said, this can be more significant on a smaller estate. And you do have an estate. It just may not be significant. But do you want to make a decision on how it's run, or do you want to make a decision on how it's run? So if you made it this far, I'm guessing something is resonating with you. As I promised, I have a specific offer for you. Again, if you come in, make an appointment through this presentation, a 1-hour consultation, you come and ask whatever you want. I give you as much direction and guidance as you may or may not want. And if you choose to use me to do more planning, I will be tickled. If you walk out and I never hear from you again, at least you're a little more informed than when you came in. So follow through. It's no charge at this point, and I want that to happen. So how do I take the next step? Click on the link below or call 832-219-8865. That way I'm going to have my people get things set up for you to come in for this no cost introduction and continuation. Because actually, that's why I can do this. You've watched this. You've taken the time. You've invested. You know more than the average person. I have to kind of retrain. And hopefully my style is better one-on-one than it is through this presentation, where as much as I'm trying, to make it conversational, there is some stiffness involved in any kind of webinar. So follow through and take action. Call the 832-219-8865. Because guys, don't do it yourself. You wouldn't do your own gallbladder operation. You wouldn't do your own vasectomy or hysterectomy. You go to a professional. That's what I am. I'm here for you, and I want to help out. And that's pretty much it. I sincerely appreciate you investing your time and energy in the webinar, and it shows how committed you are, making sure your family and the people you care about are taken care of. It's really a special thing in this day and age, and there are few people willing to do what it takes. Obviously, you're one of those. Thanks so much for attending. So, as I have said, I hope you call through. My readers, yes, I'm at that age. Anyway, please call, make an appointment. I look forward to meeting you, and not just meeting you, helping you. Thank you so very much, and have a wonderful day. Take care and be safe.